You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. We're talking newspapers today. Really interesting developments in that space. We have a new filing. It's a repeat filing to some extent. Journal Register is back in Chapter 11. What to make of it?
Oh, boy. Worries me a lot. Anytime a company is in Chapter 11 a second time, the second bankruptcy almost, well, I won't say almost always, but frequently becomes a burial proceeding.
Now, is this close enough to call it a real Chapter 22? Are the two filings close enough to add the two 11s together and come up with the famous Chapter 22?
Absolutely, because they only came out of Chapter 11 about 3 years ago. They converted a whole potload of debt into ownership. And the new owner, also a debt holder, put it back into Chapter 11, again intending to convert debt into ownership and come out the other end with a better and more profitable company. And this is not a small operation. Journal Register has a circulation of 475,000 on Sundays and a little bit less on weekdays, plus another almost 2 million in free publications. Now, keep in mind, these newspapers are not the largest newspapers in their markets. They are in suburban areas around Philadelphia, Detroit, Cleveland, and upstate New York.
What are we talking about in terms of assets and liabilities?
In the hundreds of millions, the low hundreds.
Sizable case.
It's a real case, as I said. You know, anytime you're selling 475,000 copies on a Sunday, that is a lot. The question here is this kind of a publishing business, a printing business, an industry that is a dying industry? I don't think we're going to know the answer to that question by virtue of whether or when Journal Register comes out in new Chapter 11. But the question is, will it be a Chapter 33 another 3 years from now?
Bill, I almost wonder if your closing remarks on that segment are perhaps influenced by our next segment. Perhaps you saw the program before you were supposed to, but we're talking about Tribune next. Are we done yet? This has just been dragging on for so long. Aurelius Capital Management is trying to uphold confirmation. It looks like they're not quite succeeding, so there might be some light at the end of the tunnel here.
Well, yes, there is some light, at least if you're in Tribune shoes. They succeeded this summer in getting their Chapter 11 plan confirmed. Aurelius Capital Management was a senior unsecured debt holder, but one of those who was opposing the plan because they really wanted to bring lawsuits, not settle at this stage. Bankruptcy judge disagreed, confirmed the plan. Aurelius filed a notice of appeal. They went to the bankruptcy judge, said, listen here, we want you not to allow them to implement or consummate the plan. Judge said, okay, fine with me. I'll enjoin consummation. However, you have to post a bond of, and get this, $1.5 billion, not million, but billion. Well, of course,
that's real money.
Yeah, even in bankruptcy, that's real money. They didn't post the bond. They went to a district judge. The district judge said, same thing, sorry, you got to have $1.5 billion. They went up to the Court of Appeals, and that court likewise said, sorry, we're not going to hear this little dispute now. You got to post $1.5 billion to have a stay pending appeal. The interesting question here, Lee, is this over? And that I'm not entirely sure about. I have to assume that Tribune will implement the plan in the next few weeks. They need government approval to transfer media licenses, but once that's done, they're going to implement the plan quick like a bunny. I am assuming that the appeal will still be going on at that point, and what Tribune is going to do is they're going to file a motion to dismiss the appeal, saying, so sorry, too late, even if we messed up in the bankruptcy court, you can't unscramble the eggs at this point, and they will invoke a doctrine called equitable mootness. Now, what really intrigues me, Lee, is that the courts of appeal are having a terribly difficult time right now with this notion of equitable mootness. It used to be that any time you had a confirmed plan, if it went up on appeal, the appellate courts would say, so sorry, too late, equitable mootness, you're out of court, we're not going to hear the appeal. The courts of appeal have been pulling back from that, however, and within less than the last year, we've had 4 significant opinions from different appellate courts on this complicated issue of equitable mootness. And I got to tell you, as I sit here right now, Lee, I can't find a good common thread in all of these decisions. So at the end of the day, I am not sure whether it's a foregone conclusion that Aurelius is going to be knocked out of court on the appeal. I just think the courts are struggling with this very difficult area. And frankly, as a skeptic, Lee, I think what I've seen in the decisions from the appellate courts on equitable mootness is that if they really don't like the plan that the bankruptcy judge confirmed, then they'll find a way around the equitable mootness doctrine and be able to hear the appeal on the merits. That is not much of a legal principle, but I got to say, some of the decisions in the area seem to me like they're coming out that way.
You've seen a lot of combat over the years. You've seen a lot of industries go through restructuring waves. What do you make of what's happening in newspapers? Is this simply a part of the economy that is being phased out within newspapers?
Sad to say, that's probably the case. I mean, we have several major newspapers in the country, like the New Orleans Times-Picayune, which have cut back to publishing print editions 3 days out of the week, trying to save themselves. And there are other industries too, like we just had a filing within the last day by a cafeteria restaurant operator called Piccadilly. This is one that's in, again, like Journal Register, in bankruptcy a second time. It's also a company that is shrinking in size and has been since before the first bankruptcy. And like I said, anytime you have repeat filings, you worry whether or not the company is going to be able to survive. And I think you can sort of make an analogy between cafeteria-style restaurants and old-fashioned print newspapers. In other words, are these industries that have seen better days that are simply buggy whips, which the world doesn't need much of anymore?
Not good news, but that's how you see it, I guess. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read his column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can follow our updates on Twitter and see more of our videos on YouTube. I'm Lee Pacchia. Thanks for watching.